Hi, this is Andrea Kane, and I'm here to talk to you about HIT 330. This is Healthcare Delivery Systems, and we are looking at week 10, and that is chapters 9 and 10, where we're going to talk about data privacy, confidentiality, and data security. Specifically, we're going to focus on HIPAA, ARRA, and HITECH. So as we go through here, try to be thinking about those details and items. All right, so let's dive in. This video is just on chapter 9. I'll come back later and give you a second video on chapter 10. So what is privacy? Privacy is the right to be left alone. There is no constitutional right to privacy, something just to be aware of. Confidentiality stems from sharing of private information in confidence with someone else. So as you look at your book, look also at their definitions of privacy and confidentiality. Now, two other terms you're going to need to know are use and disclosure. Use is how an organization avails itself of information internally. So whenever you think of use, think of internal within the organization. Whenever you think of disclosure, that is for outside an organization. It's how it's disseminated outside. So use is internal, disclosure is external. State laws, and I'm going to talk here a little bit about federal laws as well. HIPAA is a federal law, and it supersedes everything else. That's what it was created to do, because some states had some laws about privacy, some didn't, and it varied so much. So what HIPAA attempted to do was to say, okay, here's a basic federal law that covers every state that deals with privacy and security of protected health information. Now, some states already had laws that were more strict than HIPAA. Many of them chose to keep those. And in those cases where their state laws are more strict than HIPAA, their state law supersedes HIPAA, meaning it must be followed because it is stricter than HIPAA. So let me say that again. If there is a state that has privacy or security laws that are more strict than the federal HIPAA regulation, then those state laws preempt or supersede or are more binding, more authoritative than HIPAA and have to be followed. But for those states that don't really have very strong privacy or security laws, or may have lacked them pretty much altogether, HIPAA supersedes and preempts those state laws because it is more stringent, more strict. So you need to know this. This is a very important foundational concept. It always goes with which one is stricter. If HIPAA is stricter, you go with that, the federal law. If the state law is the stricter one, then you go with the state law. So this is where it comes into being really important that you know what your state requires. And if you live on the edge of a state where you're often dealing with another state, it's helpful to know what that neighboring state, so to speak, requires as well. So for those of you that live close to Wisconsin or Minnesota, you would want to research what their states laws regarding privacy and security of PHI is, so that you have that, so that you know, oh, in Iowa we go with HIPAA, it's federal, it's more strict, but maybe in Minnesota or maybe in Wisconsin or maybe in Illinois, we go with whatever is the most strict. And being that I'm relatively new to Iowa, I have to admit, what I have done in terms of research, it looks like we would follow the federal law. Because Iowa is a little bit light when it comes to their laws. All right, so moving on. States have laws that require the disclosure of health information, and typically these have to do with public health initiatives or vital statistics. So it says here, states also have laws that require the disclosure of health information, and I wish they would have put on here without patient authorization. There are certain cases where hospitals, healthcare organizations, healthcare providers have to provide information to the state with patient identification on it because of these state laws. So for instance, if you have a baby in or near a hospital, the hospital has to provide the birth certificate information. If someone dies in a hospital, their information has to be reported. So that's vital statistics, births and deaths. Communicable diseases, there are a list of those, and you can go out and search those if you're interested, but it's anything that's communicable. Those have to be reported. So for instance, if someone has the measles, or if someone has COVID, or if someone has a particular communicable STI, those have to be reported to the state. Patients can't stop that reporting because it's by law. Injuries indicative of criminal activity. Some examples here would be gunshot wounds, elder abuse, child abuse. Those are things that the state law says you have to report if you are a healthcare provider or a healthcare organization. You do not need patient authorization to release this PHI, this protected health information. You have to do it because of the law. So this is really important for you to know. But I would say the best way to remember it, if you're not going to remember the specifics, think about public health. What protects the public? What is it that the public, that is going on in the public realm that the state would need to know? And that may help you when it gets to the point of having a quiz or a test or something like that. I hate to say it, but we're barely into our slides and it's already at the 7-minute mark. My apologies. This is probably going to be a really long lecture video. It's not intended to be, but there's a lot of material in here, and this is material you really, really need to know because it is so foundational. All right, HIPAA. We're getting into HIPAA. The first thing I want to point out to you is HIPAA only has one P. So when you're spelling HIPAA, it is HIPAA. Do not spell HIPAA HIPPA. Please, please do not do that. I will mark it off. And we of all people, we study this. We are supposed to be knowledgeable about this. So make sure you use the right abbreviation when you're doing this. Under HIPAA, there were 5 titles in that act. Title 2 is the one that addresses medical liability reform, healthcare fraud and abuse prevention, and then administrative simplification. Under administrative simplification, what they focused on were privacy and security standards for protected health information, transactions, identifiers, and code set standards. So let me say that again, transaction, identifiers, and code set standards. They wanted to make it so that everybody had to use the same transactions, the same identifiers, and the same code sets. And before that, they wanted to make sure everybody understood these are the universal privacy standards for protected health information. These are the universal security standards for protected health information. And we'll talk more about protected health information in a bit. But you need to know that PHI includes any and all health records, whether they are in paper form, electronic form, microfilm, microfiche, video. If it is a health record with individually identifiable patient information, it is PHI. Okay, so moving back here under administrative simplification, privacy and security, then the standards for code sets, transactions, and identifiers. It also mandated that all providers had to have an NPI number, a National Provider Identifier. And so if you hear about NPI numbers, every provider has a unique National Provider Identifier. And actually, every healthcare organization does as well. That's all part of this. The next act we want to talk about is ARRA, American Recovery and Reinvestment Act. ARRA had some specifics in there that actually went back and modified HIPAA, the original HIPAA privacy rule. And you hear a lot about high tech, the Health Information Technology for Economic and Clinical Health Act. That is actually a subset or a part of ARRA. So HIPAA and ARRA are these two main federal acts, and high tech is a subpart of the ARRA, just so you know that. And it was an ARRA and high tech both had changes for the HIPAA privacy rule. And that should be in your book if you want to go through the specifics of how it changed. One of the things that, sorry, let me go back. One of the things that happened was they said that patient information, or PHI, was no longer protected under HIPAA 50 years after someone passes away. So if someone has been deceased for 50 years, their information, their PHI, is no longer protected under HIPAA. So that's one of the examples they give of what changed. Because prior to that, it was all PHI for eternity. All right, so ONC, you'll hear about that a lot. Office of the National Coordinator for HIT, Health Information Technology. It is within the Department of Health and Human Services, DHS. They are responsible for coordinating national efforts to implement and use health information technology. Their goal is to get everyone on electronic health records because they want to promote the exchange of electronic health information. They want to make it so that if you or I from Iowa head off on a vacation, whether that's Florida or Alaska, or Maine or Hawaii, that if we need health care in one of those very far-flung places, that our information is available electronically to the caregivers there so that they can give us the best possible care, especially if we're in an unconscious state and unable to communicate our health history and that sort of thing. All right, so who does HIPAA apply to? Who does HIPAA govern? Well, HIPAA applies to what is called covered entities. And covered entities fall into three categories: healthcare providers, health plans, and healthcare clearinghouses. So if you are a healthcare provider that conducts financial or administrative transactions electronically, and I can tell you that pretty much every single one does in this day and age of 2020, you are a covered entity. If you are a health plan, insurance company, that type of thing, you are a covered entity. If you are a healthcare clearinghouse, and I would encourage you to take a look at that. Let me really quick look and make sure that that definition is in your glossary so that you can have that. All right, let's look. Yes, page 723 in your glossary. A clearinghouse is a vendor that processes healthcare claims for a healthcare organization. Okay, so if you're not sure what a clearinghouse is, go to your glossary, look on page 723. It's a vendor that processes healthcare claims for a healthcare organization. They take a look at claims and identify if there's anything missing, if anything is wrong, and then send those on for reimbursement. So these are what covered entities are. So what would not be a covered entity? Well, an attorney would not. A courthouse would not. A florist would not. A pastor or someone in a religious setting who might visit a patient in the hospital is not. A pharmacy would be a covered entity because they're conducting financial or administrative transactions electronically and they are providing health care. A physical therapy company or a home healthcare company or a nursing home. Those are all healthcare providers that conduct financial or administrative transactions electronically. They need to get paid. And that's how this all happens. There's no more cash. There's no more paper checks that come into healthcare providers to pay for care. That isn't how it happens. It's all electronic transactions directly into bank accounts. And so that's why so many of them are covered entities. All right. Oh, and another example might be a funeral home. They are not a covered entity. I'm trying to think of anyone else. A daycare provider is not a covered entity. It's only if it's a healthcare provider, a health plan, or healthcare clearinghouse. All right, so who else does HIPAA apply to or govern? Well, it governs anyone who works with a covered entity. If someone is performing functions or activities on behalf of a covered entity that involve use or disclosure of that PHI, they're called a business associate. And you have to, as a covered entity, have a business associate agreement with this vendor or this business associate, this contracted service, however you want to look at it. The content has to have specific things in it, meaning that business associates have to follow the same HIPAA rules as covered entities when it comes to use or disclosure. And if they don't, they have to have penalties for that. And those penalties have to be the same as what a covered entity would face. So for instance, in my past life, we had quite a few business associates agreements. When I outsourced transcription, I had to have a business associate agreement with my transcription service. Off and on, I have worked in situations where release of information was outsourced, and they had to have a business associate agreement, as well as a contract. The business associate agreement always went with the contract with the company. We had a company that we worked with that helped us with coding audits, some really tricky stuff. The ones that we knew really needed to be looked at by outside eyes. That was a contract with a business associate agreement because they had access to PHI and they were either using it to perform the work that we hired them to do, or they needed to disclose it. In the case of the release of information company, they had to disclose that information to fulfill release of information requests. So that is all about business associates. Who are workforce members? Because under HIPAA, it talks about workforce members. Well, they're employees, volunteers, student interns, which would include all of you when you do your PPE 1 and PPE 2, trainees, employees of outsourced vendors working routinely on site. Those are all workforce members. Contractors are based on whether they're a business associate or directly contracted and working for the organization. So there's some wiggle room there. And again, I would direct the person in order to figure out, are they part of the workforce members of a covered entity versus a business associate. My question would be, do you have a contract with a business associate agreement? If you have a contract with a business associate agreement, you are not a workforce member of a covered entity. You are covered under that business associate agreement. If, however, you do not have a contract with a business associate agreement, then you're a workforce member. Protected health information. Okay, so now we're going to get into PHI and talk about what in the world is PHI. Well, it's held or transmitted by a covered entity or business associate in any form. Any form. Don't be tripped up by paper or electronic. It's any form. It can be video. It can be microfilm, microfiche. It can be oral, like they said, in terms of just a voice recording. It can even be telehealth where you're doing remote monitoring. That's still PHI. It's PHI is individually identifiable, and hopefully your book talks about that. I have 6 classes. So even though I read, even though I try and read everything every week for each class, I have to admit they blur together because some of my stuff gets very similar, even though it's second year versus first year. And so sometimes I trip up. I'm not sure if I'm repeating myself or if I've missed covering something. So I apologize and I beg your patience with me on that. I'm trying to be on these videos a little more detailed than I have been in the past, which will make our videos longer, but hopefully will help you when it comes to maybe something that might not be clear in the book, or that you get to the test and hopefully it won't be new, because I'm trying to work on that. All right, so I wanted to pull up individually identifiable health information. If you look in the glossary of your textbook on page 739, it has a very long paragraph defining exactly what individually identifiable health information is. The challenge is that there can be a number of elements to make something individually identifiable. And so rather than list out all those elements, PHI and our government went with the ubiquitous term of individually identifiable, whatever that means. If you can look at some type of information, health information, and you can identify the person, or you have enough information that you think you can identify the person on an individual level, then you have PHI. You may not have their social security number. You may not even have their name. You may have initials, date of birth, date of service, and then their diagnosis. If you are able to identify someone on an individual level with what you have, then it is PHI. So don't get tripped up if someone says, oh, there's a social security number on there. Well, that just makes it PHI. It's so much easier. But PHI can be without that. PHI can be a last name, a room number, and a doctor's name. I mean, if you can identify it that individually. Sorry, my computer jumps sometimes. Anyway, look at the definition on page 739 in your book to go through and see the very technical definition. PHI relates to a patient's past, present, or future physical or mental health condition, the provision of health care, or payment for provision of health care. So if it has anything to do with a physical or mental condition, even if it's past or future, if it has anything to do with health care that's provided, to be provided, has been provided, or payment for some type of provision of health care, it is PHI. So these 3 qualities are what make up PHI. So yes, it can be individually identifiable, but it has to be related to a health condition or provision of health care or payment of provision of health care. And it has to be held or transmitted by a covered entity or business associate agreement or business associate. So don't get tripped up if it's a Post-it note from a florist. Is that PHI? Even if it's individually identifiable? The answer is no, because it doesn't relate to the patient's health condition, provision of health care, or payment, and it's not held or transmitted by a covered entity or a business associate, right? Because florists don't provide healthcare clearinghouse, healthcare insurance or healthcare provision. So just because it's individually identifiable does not make it PHI. And again, just because it's held or transmitted by a covered entity or business associate does not make it PHI. It has to be individually identifiable, and it has to be related to those other things listed there at the bottom. So just make sure that you're aware of that, the nuances to that. We tend to have when you're in the field, for those of you who are working in the field already, you may already be, oh, anything is PHI. Well, that's because if we work for a covered entity and it's individually identifiable, we typically make it PHI to live on the safe side of life. But this is the true requirement of the HIPAA legislation, the HIPAA law. All right, what is de-identified information? Well, de-identified is exactly what it sounds like. It does not identify the individual. If you have de-identified information that does not identify the individual, it is not protected by the HIPAA privacy rule. However, in order to de-identify the information, there are a minimum of 18 elements that have to be removed in order for it to qualify as de-identified information. And I'm not going to list all those out, and trust me, that will not be on a quiz. You just need to know de-identified information does not identify the individual, it's not protected by HIPAA, and there are lots of elements that have to be removed in order for that information to become de-identified instead of PHI. All right, so, oh, I talked about this earlier. My apologies, I jumped ahead. And this was an ARRA / high-tech change that came. So please remember that if someone's been deceased for more than 50 years, more than 50, their PHI is no longer protected. All right, HIPAA applicability. All right, so who does HIPAA apply to? And how does that work? Well, the patient, the individual, the consumer is the person who is the subject of PHI. They're the ones that HIPAA applies to. But it also applies to their personal representative if they have one. And a personal representative is someone who has legal authority to act on another's behalf. Examples would be a healthcare power of attorney. A healthcare power of attorney has that authorization, that legal authority to act on the person's behalf. Another example would be a parent of a minor child. And I don't want to get too much into that. You'll cover that a lot next spring in your, not this coming spring, but a year from this coming spring, the spring of your second year, when we get into the legal class. But under quite a few situations, parents of minor children are their personal representative. And I won't get into any other examples, but that kind of gives you that. All right. There is something under HIPAA called a designated record set. And this is what is developed. The designated record set includes health records, billing records, various claim records, and all of that, decisions about an individual. That is what is in a designated record set. And HIPAA applies to that. But who determines that designated record set? That would be the healthcare organization. They're the ones who determine what all is included in that. And I'm going to, let me really quick go back to that. Designated record set. Look in your glossary on page 730. There is a really good definition. Now it's got a lot of words in it because they pull it right from the law. But there's a really good definition for designated record set on page 730. So make sure that you go through that because I think it will be a little bit clearer once you read that definition and go through that. All right, so minimum necessary. What in the world is minimum necessary and why do we even need to know about it? Well, one of the things that HIPAA did was for the first time, it really came out and said that if you're going to use or disclose information, you need to use the minimum necessary to complete the task. Meaning, if you can get by with looking at one document, only look at that document. Don't look at the entire record. Use what is minimally necessary to accomplish the purpose for what you're doing, whether that be release of information or whether that be billing, whether that be some kind of internal use. So for instance, a patient says, I would like my x-rays to be sent to my attorney. What HIPAA did was say, only send the x-rays to the attorney and only the x-rays for the visits that the patient requested. And you need to ask the patient which visits, which dates of x-rays do you want sent to your attorney, because it's limiting the information to what is minimally necessary to do the job. It's not opening up the record and saying, not only will we send the x-rays, but we'll send the consent forms, we'll send the H&P, we'll send the consults, we'll send all these things. No, if the patient's requesting just these x-rays and just from this visit, that's all we need to do this work, and so that's what we're releasing. Another example is how, and we'll talk about this in other classes as you go through the program. The other thing is access in the computer is limited by your job, by the role that you have. So for instance, a nurse is going to have different access than a dietitian, who will have different access than a physical therapist, who will have different access than a social worker, who will have different access than an HIM coder. The access is on a job-based need to know. What do you need to know to do your job? And minimum necessary is like that. It's what are the basics that you need to be able to do what you're supposed to do. But minimum necessary is really about use and disclosure and handling requests and limiting those. So that is one of the things that HIPAA brought to the table for the first time nationwide and said, you know, this is not a point of being generous. This is a point of limiting and protecting. So then we get into the famous TPO, Treatment Payment Healthcare Operations. HIPAA went on to say that for treatment payment or healthcare operations, you do not need patient authorization to release or use or disclose information. But for anything else, you not only need patient authorization, but you have to track your disclosures. You have to do what's called an accounting of disclosures if it's for anything other than treatment, payment, or healthcare operations. And I think this is a really good, HIPAA brought a number of really great things nationwide when it came into being. And like any law or regulation, it has its issues, and some of those are still being worked out all these years later. But for the most part, many of the pieces of structure that were put into the law were really beneficial to patients and helpful, and made healthcare organizations and providers more accountable. Because prior to this, unless your state law said specifically you had to, you didn't have to keep track of who you released information to. Now I will say that most organizations were smart enough, healthcare organizations were smart enough to know that that was not wise in terms of practices, and so they did keep track at least of most of them. But this really put rubber to the road and made healthcare organizations and providers and payers and insurance companies and clearinghouses accountable for what they were doing. That if the patient requested that accounting of disclosures, they had to provide it. So that's what this is about. So let's take a look at your glossary again. And on page 762, there's another big long section here on treatment, payment, and operations, TPO. So I'm going to refer you back to that. Make sure you look in your glossary because that'll have some added information which should be helpful. All right, individual rights. HIPAA gave individuals rights to provide some control over their health information. They don't have total control, but they have some. These are some of the major individual rights that HIPAA granted to people for their PHI. They have the right of access, meaning that they have a right to see their PHI. Now, I will tell you that they are limited when it comes to psychotherapy notes. They are not granted right of access with psychotherapy notes. And the reason for this is that there has been a long-standing rule that psychotherapy notes are super confidential and they cannot be released without approval by their physician that the information in those psychotherapy notes will not be hurtful, harmful to the patient. So if a patient comes in and says, I want all of my records, well, we can give them everything except their psychotherapy notes, and that may require an additional authorization process with their psychiatrist or that sort of thing, or whoever is the physician that is over their care. But otherwise, outside of psychotherapy notes, for the most part, individuals now have the right of access. They can't be refused to have a copy of their records. They have the right to request amendment. A patient now under HIPAA can say, I disagree. In my ED note from last week, you said that I appeared to be intoxicated because I had slurring of speech, I was having difficulty controlling my movements, and I smelled of alcohol. And I disagree. They have the right to request the amendment. Does that mean that the amendment is automatically going to be done? No, but they have the right to request that, and every covered entity has to have a process in place whereby the amendment goes to whoever wrote the entry, and that individual determines whether or not they are willing to make an amendment to the entry. If they're not, or an addendum in a lot of cases rather than an amendment. If they're not, then you have to communicate back with the patient and explain the person who wrote the entry is not willing to amend it or addend to it. However, we will take your request for amendment, we will make it a part of your permanent medical record so that it is on file as having requested amendment. Or it may be that the provider decides, I'll go ahead and amend that. And then they do, usually through an addendum. And then you notify the patient, yes, the provider agreed and they amended the record. But now under HIPAA, patients have the right to say, I want to request to have my record amended. They have a right to accounting of disclosures, which I talked about a little bit before. They have the right to request restrictions. They can say, I don't want my records submitted to my insurance company because I'm going to pay for all of this out of pocket. And as long as they do that, you cannot send that information on to the insurance company if the patient has paid for everything out of pocket and is not utilizing their insurance for that visit. You can sometimes some of the restrictions I have seen have involved exes, that maybe someone was in a difficult relationship and they decided they're going through a divorce and they don't want their spouse to be able to access their record. It may be a minor that wants to request restrictions based on the content of what's in the record. They don't want their parent to have access. So patients have the right to request restrictions. Do those restrictions always get approved and implemented? No. In the case of the minor, if it doesn't fall under law that they can request the restriction, then we can take their request and make their request part of the permanent record, but we can't actually implement the restriction. Right to request confidential communications. Yes, they can request that anything that was confidential that's communicated can be, that they can have access to that. Sorry, just a minute. I'm looking for something. I wanted to. Yeah, I was hoping that they had confidential communications as a item listed in your glossary, and they don't. The best that they do is talk about confidentiality, which is still worth looking at. That's on page 725. And then patients have the right to complain of privacy rule violations. They have to be provided with a notice of privacy practices the first time that they encounter that particular or healthcare organization, or if it's like a provider that's independent, the first time they have services there. They are to receive the notice of privacy practices. And if they feel that their privacy has been violated, they have the right to complain about that to the Office of Civil Rights, and who will then follow up and investigate. And they also have the right to complain to someone within the organization of privacy rule violations. You have to have a privacy officer under HIPAA, and the notice of privacy practices has to state who in the organization handles privacy rule violation complaints, and who to contact and how to contact and all of that. So right of access, we talked about psychotherapy notes, information compiled for civil or criminal actions. So for instance, let's say, well, I'm not going to give an example. It's probably best not to. I think you guys can figure that out. So anyway, typically you have to make it available, and there are sometimes exceptions. There are times when you have to deny access, but they may have an opportunity to review the information. They may not. They may also have an opportunity to have their request reviewed or not. So I'm not going to get too big into denial of access. Whatever your textbook says about it, I guess we'll go with. All right, so access request, it has to be provided in writing. A timely response is required by the covered entity. They have to do it within 30 days of receipt. They can have another 30-day extension. They have to have a written statement to the individual within that first 30 days that says, oh, we believe your records are on microfilm, microfiche. We are in the process of researching those. We'll get back to you as soon as we have those. So that would be an example of an extension, especially if the records are stored off-site or that sort of thing. So that's really what that is. And if the person requests them to be in paper, you have to usually put them in paper. If they request them electronically, you have to determine, are you going to use like a flash drive or a USB drive, or are you going to put them in an encrypted email? Are you going to upload them to a patient portal site where they can get in and have access to them? How is that all going to work? And in the patient, the person who's requesting, it has to be whatever works best for them. Charges, I'm not going to touch on this very much at this point, except to say that yes, you can have a reasonable fee, and the OCR recommends a $6.50 flat fee. My personal view and my experience has been I never charge a patient for requesting records for whatever reason. I just don't do that. And a different tact on that is If we have someone who's requesting a several hundred page chart in paper form multiple times, then yes, I will work on a charge. But other than that, I really try, when I was in that world, I tried very hard to never charge a patient for a copy or for access to their records. I just personally don't believe that that's good practice. But there are others that disagree with me and who want the revenue that comes from release of information, and they tend to be more aggressive in their charging. Okay, so right of access, they can get it, they can ask it to be transmitted to a third party, they have to do an authorization form. Unless they're the ones who initiate the request. And you have to be really, really, really careful with this. Some people will want to call up on the phone and say, I am Mrs. Smith and I want my records from my ED visit to be sent to person XYZ. Well, is this really Mrs. Smith on the phone? And if so, how do we know? How do we verify that? How do we know it's not Mrs. Smith's neighbor or Mrs. Smith's daughter or Mrs. Smith's um, ex husband's ex-wife? You have to be really careful. I'm not saying you always need an authorization form, but there has to be something that we can compare to make sure that we are getting a valid request. Right to request an amendment. Um, Again, you want it to be in writing. You want it to explain why they're wanting the amendment. And then you have to have a process as a facility, as a healthcare provider organization. You need to know what you're doing and how you do it, and that all has to be laid out so it's very clear and reasonable and consistent. I mean, I think that's the key with all of these is to be consistent. Because if you have policies and procedures and you follow them, you're able to then make sure that everyone's getting their needs met, but within the confines of the law and the organization's rules. Accountings of disclosure, talked about that too, so I'm not going to linger here. Disclosures that don't require an accounting. This gets a little more specific than I was. These are ones that are outside of treatment, payment, or healthcare operations. So even though treatment, payment, and healthcare operations are the main things that you don't have to do an accounting of disclosures for, these also are ones you don't as well. And then what is included in accounting, it's the date of disclosure, who was the information disclosed to, and what the purpose was of the disclosure. And you definitely need to make sure it's timely. And then restrictions on use and disclosures. So this is just exactly how it is on the screen. The right to request confidential communications. You can ask that there be alternate routing or destination or alternative methods. Some people do not like to have confidential communications by text on their phone or through email. And that's fine. They can request that they not be that way. They can also request um, that they go through a portal or some other way. So they have the right to request how they want to receive things or how they don't want to receive things. And then again, this was about the complaints. you can complain to DHS, but they're going to forward your complaint to the Office of Civil Rights. So, same difference. Notice of privacy practices, talked a little bit about this. They are there to inform patients of how their information will be used and disclosed and what patient rights are for PHI. The notice has to be very available. There's certain required content that has to be in the notice of privacy practices, and there has to be a written acknowledgement by the individual. That's why they always make you sign. Consent. All right. Consent is when you say it's okay to use or disclose my PHI for treatment, payment, healthcare operations. It is an optional document. There is required content and it can be revoked. Authorization, though, is different than a consent is different than authorization. Consent is basically you're agreeing with the organization that yes, you realize that they are going to use and disclose your PHI for treatment, payment, healthcare operations. You're just acknowledging that. Yeah, you know that under the law, the organization has the right to do that. Authorization, on the other hand, is saying, I authorize you, healthcare organization or provider, to release my PHI for this purpose, and here's what I want released, and that sort of thing. I am going to, yes, yeah, the authorization. If you look on the bottom of page 718 in the glossary of your book, it gives you the definition for authorization. Make sure that you are familiar with that. Make sure you understand the definition there. There are situations that require an authorization, such as release of records to an attorney, release of records to your next door neighbor, release of records to maybe a daycare center or that type of thing. There are situations that do not require an authorization. Basically, you can call up and say, I want my records released to this doctor because I'm going to be following up with him. In that case, it involves treatment. It doesn't need patient authorization since we're sending it directly to that provider and following through on that. Okay, so let's see. There are required uses and disclosures without authorization. Just talked about that. Permitted uses and disclosures without authorization. Patient has the opportunity to informally agree or object, and examples of that are directory of patients. When you go into a hospital and you're going to be there as an inpatient, you have the right to say, I want to opt in to the directory of patients or I want to opt out. What that means is basically that you're on the list, and if the florist calls or your pastor calls or your friends or family call, that they will acknowledge that you are there and maybe even give them your room number. When you opt out of the directory, they can't even say that you're there. They can't even admit that you are in the building. So those are ones where you as the patient, you as the individual has the opportunity to agree or object, to say I'm going to opt in or I'm going to opt out. So again, this talks about when can you use and disclose PHI without patient authorization. And again, it only works if it doesn't violate a stricter or more protective state law. So treatment, payment, healthcare operations to the individual themselves, incidental disclosures, limited data sets, and 12 public interest and benefit purposes. Think public health, or state law. All right, I want to talk about incidental disclosures for a moment. And I'm hoping incidental disclosure, does it talk about that? It does not. I am disappointed that incidental disclosure is not here in the glossary. All right. So let's see here. Surely it talks about it in your book. Yes, if you look at page 268 in your book, it talks about incidental uses or disclosures, that they occur as part of a permitted use or disclosure. For example, calling out patient names in a physician office is an incidental disclosure because it occurs as part of office operations. It is permitted as long as the information disclosed is the minimum necessary. So, incidental disclosures can happen without patient authorization. So let's say that, as the example that they give, you go in to a hospital, to the radiology department, because you're going to get an x-ray, and you sign in and you do everything you need to do for all of that, and then they call your name to take you to the back to do your x-ray. That's an incidental disclosure. They gave out individually identifiable information, but they did not do it in such a way as to be malicious about it. It was simply to identify you, make sure you were the right person, and to continue on with your treatment. So in that case, it is an incidental disclosure and it does not require patient authorization. Hopefully that explains that and is helpful. All right, and here are the 12 public interest and benefit purposes. Talked about research, law enforcement, victims of abuse, neglect, or domestic violence, specified wounds, for instance, like gunshot wounds or knife wounds. If there's some type of tissue donation going on, if there's a threat to health or safety, and workers' comp. So there's all sorts of ones that are listed where information can be used or disclosed without patient authorization. Disclosure of students' immunization records is now considered a public health disclosure. It did not used to be. I remember the days where we had to get patient authorization, meaning mom or dad had to sign a patient authorization in order for us to release their child's immunization records to the school. That no longer is the case, thankfully. Now it is part of public health disclosure. You should get oral agreement, but you don't have to have written authorization. So if a parent calls up and says to their pediatrician's office, I need you to send a copy of Susie's immunization records to school ABC, that is enough for the office to be able to send those immunization records directly to the school. And then research, this just goes through that typically if you're involved in research, you will sign a boatload of consent forms, and at least one of them will talk about how your information, your PHI, will be used and disclosed. And if it is something that is not mandatory required, they have to get your consent for it, just so you know. All right, so what happens when there is a HIPAA breach? Well, that's not good, but they do happen. This starts on page 270 in your book, and it defines what a breach is. It talks about exceptions to the breach rule, and it goes on to look at the 4-factor risk assessment used to determine whether PHI has been compromised. I'm going to refer you to your book since we're closing in on 1 hour, and I'm sure you don't really want to listen to a whole lot more on this. But anyway, look at your book because page 270 particularly has really good information. And again, on the top of page 271, where it talks about breach notification requirements apply only to unsecured PHI. So make sure that you know that. You only have to report breaches if they involve unsecured PHI. And what does that mean? That definition is there, and I know it's also back in your glossary. And then it goes on to talk about those unsecured PHI breach notification requirements. So, yep, this is in your book. Look at pages 270 and 271. And again, your book. And this just gives you an example of sometimes things can seem like a breach, but they're really not. And then this talks about the 4-factor risk assessment. And then how do you do breach notification? And we will get into this again and again and again. So please don't feel like this is your one and done type of situation with all this information. We're only going to touch on it this one week, but you will get it multiple times over. And then the next part of this is all about marketing. Marketing is, whenever PHI is used for marketing, it has to have patient authorization. So if you've ever turned on the TV and you've seen a commercial for a healthcare organization or provider and they've interviewed a patient, maybe they've had hip or knee surgery, or maybe they had something that went wrong with their heart and they had some kind of cardiovascular surgery, and then they went through cardiac rehab, and they're telling the story of the patient and how their provider did such a wonderful job and this healthcare organization did such a wonderful job, and they feel like now they have their health back and they'll be able to enjoy the rest of their life. That is marketing. And in order to be able to share all of that PHI, they have to have patient authorization. There are times where marketing activities do not require an authorization, and when what those cases are is when you're face to face with the individual, not video, but face to face, and it is involving something that is of nominal, minimal, limited value, like $10 or less, or even $5 or less. Those would be examples of that. And that is all covered on page 272. So look at page 272 to look at a lot of the marketing. Looks like it actually starts on page 271. Yeah, bottom of 271, looking at 272. All right, let's see here. And this just continues on with marketing. Talks about sale of information. And then fundraising. You have to allow people to opt out of fundraising communications that meet the definition of healthcare operations. You have to allow them that. Administrative requirements. What does HIPAA require in terms of administration of the rule? Well, first you have to have a privacy officer. You have to designate someone in your organization, even if it's a physician office, who is your privacy officer. You have to have standards and policies, procedures. You have to have workforce training. You have to establish privacy safeguards. You have to have sanctions. You have to prohibit against retaliation and waiver. and you have to document and record retention. Document and record retention of all that information. Enforcement and penalties. There are lots and lots of penalties when it comes to HIPAA, and we will research these as you go through some of your other courses. But if you're looking at your book, at the bottom of page 273, it's going to talk about penalties. And yes, it is permitted that state attorneys general may bring civil actions based on alleged HIPAA violations. Not only would you be in hot water with the feds, but you can also be in hot water with your own state attorney general. So read about that. Bottom of page 273, top of page 274, and notice it talks about audits. Audits are the best way to make sure that things are happening as they're supposed to be happening, or to identify that things are not happening the way that they were supposed to be so that you can intervene and get them fixed. You often hear about audit trails, how in an electronic health record they'll go back and run audit trail audits, and they will look at who has accessed a particular record, usually of a celebrity or a sports figure or a prominent politician or prominent individual in the community, and just make sure that no one has accessed that record or done anything with that record that should not have. I'll give you the example. In Minnesota, I understand that quite a few individuals looked at George Floyd's medical record and did not have authorization, did not have a job-related need to know, and they were dealt with quite severely for that, as they are supposed to be. You have to have sanctions in place and consistently apply them when people break HIPAA. Otherwise, you'll have the federal government on your doorstep, not to mention your state attorney general. So anyway, that's all of that. All right, so disclosure of health information. That is also known as release of information, and that is a process that is provided in pretty much every HIM department across the universe. And there are steps in that process. You enter the request into the ROI database, you determine the validity of the authorization, you verify the patient's identity, and then you process the request and make sure that you complete everything in the database so that you have an electronic record and all of that. This starts on the bottom of page 274 and goes on all the way through to page 277. And it's going to talk about authorizations as well. So I'm going to not go into a whole lot of detail here, except to say that yes, you definitely have to monitor turnaround times. You also have to monitor and do audits to make sure that the appropriate information was released. Minimum necessary, again. You got to go back to that. Was that done? Was the authorization appropriate and accurate, and did we confirm that everything in it was as it should have been? And that's where it talks about accuracy here. Did they use a HIPAA compliant authorization form? Because that was one other thing that HIPAA did. It basically said you have to have these elements on your authorization form. And prior to that, you could use a Post-it note for an authorization form, but HIPAA really said, no, you've got to have these established elements on here. And so you're making sure that the right form is being used. And then it goes into medical identity theft, and unfortunately, this is a rising crime, and it happens. So that's a big reason why you have to verify the patient's identity and make sure that they really are themselves and that they really are authorizing what they're authorizing. Because in some cases, I ran into this when I was in North Carolina. There was one particular organization, and I won't give too many details because I don't want it to be identifiable, shall we say, but there was an organization that employed a number of individuals. And this organization provided them with insurance cards, but they did not have a photo ID on them. And one of the challenges we had was that these insurance cards without any identification were utilized by more than one person. And the way that we found it out had to do with birth certificates. We had pregnant moms who would come in under an insurance card, and they would have their visit created under that name and that identity. And after their child was born and we went to do their birth certificate, we would find out that they were not the person that they had presented themselves as being. They were not the person on that insurance card. They were not that person that they had registered as or anything. They were someone totally different. And the only way we found it out was that on their child's birth certificate, they wanted their real name and the real name of the child's father on that birth certificate. And so then we had to start unraveling and figuring out exactly who is this individual, create a new medical record number, figure out what information belonged to them that didn't belong to the other person and move it over. And so that was a huge challenge. It also happens sometimes in the ED. And it's one of the reasons why a lot of healthcare organizations look at biometrics or they ask for a photo ID, is because they're trying to prevent medical identity theft. All right, so moving on. You've read the screen, hopefully, and you have looked in your book. It starts on the bottom of 277 about medical identity theft. Please make sure that you are aware of the FACTA Act, the Fair and Accurate Credit Transactions Act. And then patient advocacy and compliance. HIM professionals are typically thought of as the steward of the patient record. And we try very hard to advocate for patient-centered healthcare, for patient empowerment, for health literacy, access to the health record for patients. And we want to encourage others to comply with the laws and all the rules and policies that are applicable to healthcare organizations. And that is one of our job, is to stand up when we see something happening that probably shouldn't be happening, to stand up quietly, privately, professionally, and say, hey, we need to do things differently, or here's what is the rule, and I'm concerned because I'm seeing XYZ occurring. And then it goes into talking about compliance. And this week you will have an assignment where you look at compliance and security, privacy and security and compliance. What are they? How do they work together? Those types of things. So I'm not going to spend a whole lot of time with that. All right, that is it. I'm sorry it took me so long to get through that chapter, but it was a nice long one. I will try and be much more quick on the next one if at all possible. So take care, have a good week, and I will be back soon to talk to you about Chapter 10.